So, sir obviously needs not a lot of introduction. Yet, cutting directly to the chase, I will very briefly introduce sir, and I will hand over the class to sir for taking this forward. So, Shri Anand Grover, sir, is going to be speaking to us on the topic of access to medicine and right to health. We welcome sir. Sir is a senior advocate. He is an adjunct professor of law at Georgetown Law Center, Georgetown University. Shri Anand Grover is a designated senior advocate practicing in the Supreme Court of India. He is the director of Lawyers Collective India and the former United Nations Special Rapporteur on the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. This was from 2008 to 2014. In his regular practice, Mr. Grover has argued several landmark cases in the field of public interest and human rights law, including mass eviction cases, Olga Tellis and others versus Bombay Municipal Council, environmental cases such as the Bhopal gas disaster, the LGBT rights NAS Foundation case. Mr. Grover has also done innovative work in the field of patent law, opposing the grant of patents for essential life-saving drugs. He successfully argued the first constitutional challenge to Section 3D of the Patents Act 1970 on behalf of the Cancer Patients Aid Association in Novartis versus Union of India, the patent linkage case of Bayer versus Union in India, and successfully defended against a challenge to the compulsory license issue for the manufacture of a kidney cancer drug in Bayer versus Natco. He was appointed the special public prosecutor in the 2G case by the Supreme Court of India. He is the lead counsel in the Bhima Koregaon case, in which he secured bail for Vara Vara Rao. During his time in the UN, he has focused his reports to promote non-discrimination, empower vulnerable groups, and ensure meaningful participation of affected communities. Sir, it's our humble privilege to be welcoming you today. We warmly welcome you, sir, and on behalf of our entire team, I hand over the class to you, sir, and I request you to kindly take it forward.
Thank you very much. It's a great pleasure for me to be able to talk to lawyers and actually converse with them. Keshav actually asked me to do this, and I readily agreed because I think it's very important to do work free of charge. My entry into the legal profession was actually planned so that I could actually do free work for poor people, because I find that even today, access to justice is not available to poor people. So even today, I do 50% of my work free of charge for various people, including labor, women's rights, and of course, access to medicines, health, and criminal cases for liberty. Now, I want to talk on access to medicines, and I'm going to share my slideshow with you. So let me just get it together. Can you see it?
Yes, sir, it's there.
Okay. So I'm going to basically, I'm going to talk on access to medicines and the right to health. But the most important part in access to medicines is right to health. The realization of the right to health is in fact determined in terms of money by access to medicine, because costs of medicine actually is about 50% of the cost of treatment. So unless you actually are able to afford medicines, it's very difficult to secure the right to health. So that's why I'm talking about it. There are other issues, for example, free trade agreements. We just don't have the time. I will talk about costing of medicines because there's a huge myth if I have time. But today I will concentrate on access to medicines and patents, which is one of the intellectual property rights, and how historically India has changed its laws pursuant to decisions by the government earlier on, then because of the international treaty, and how that is fading out, and how there is now a change which is towards the worse actually. So let's just have a look at it. The right to health is part of the international right on in the Convention on Economic, Social and Cultural Rights. We are actually signatories to that convention, and it's a binding obligation on India to have the right to health secured. So this has been done in India either by legislation, like for example, Rajasthan as one of the states, and also by executive action like Delhi government and the Punjab government are now actually forging ahead on health issues. But what is the meaning of the right to health? Now, the right to health is not the right to remain healthy. It's actually the what is known as the availability, accessibility, acceptability, and quality of health goods, services, and facilities. This is the expression: health goods, services, and facilities. So goods include essential medicines, and these are what are known as the part of the core obligations. They are not derogable. The government cannot say we will not provide them. So if they don't provide them, if you're a signatory state to the International Covenant on Economic, Social, and Cultural Rights, a person can go to court and say you have to provide them. That's why there are lots of judgments on health and access to medicines. And I'll show how in the patent landscape this was very important. So what is the meaning of accessibility? The accessibility issue is this area of law in international law, right to health, which is Article 12 of the Economic, Social and Cultural Rights Covenant, has been elaborated, as are most other rights, in what are known as general comments. So general comment 14 is about the right to health. And basically, I've actually condensed it. It's actually has an overarching principle, which is non-discrimination. And non-discrimination, by the way, is an overarching principle in international law. So you can't discriminate on so many grounds. But discrimination, as I try to explain in the same-sex marriage, is not what we understand under Article 14, 15, and 16. It's not only on the basis of doctrine of classification or arbitrariness. That you can actually have a look at in CEDAW Article 1. If you have the time, you look at that. So there cannot be any discrimination in terms of access to medicines. Access means physical accessibility. For example, you roll out a program for the availability of cancer medicines. Obviously, you cannot make them available immediately in all areas because rural areas are less accessible. So first of all, there has to be a plan to do it, but we'll come to that. So physical accessibility is very important. The other thing is economic accessibility, which means it has to be affordable. So you can't have a medicine which is, costing crores of rupees, as there are some medicines, because then they become unaffordable. Apart from the actual economic and physical accessibility, there is the notion of information accessibility. So even information must be available about medicines. Now, the other thing is that apart from the right to health, there is the other Article 27, which talks about the right of everyone to share in scientific progress. So, you can't have a situation like we had in COVID. You'll ask me, what is the purpose of these rights? Because they were not realized in COVID. That's the challenge. I mean, we are not getting into that. So basically, any scientific progress which actually has an impact on health, also that information must be made available. Benefits should be shared. Now, importantly, you have to understand the persons who invent medicines are human beings. They are not corporations. They are paid by corporations. Okay. So there's a bit of a conflict between who is the inventor. And if you look at any patent application, they'll have the name of the inventor, who will be an individual person, and maybe that person is working with a corporate entity. So corporates and inventors have distinct responsibilities, but I don't want to go into that because that's another complex area. Now, what are the intellectual property rights? Because patent is an intellectual property right. There are a number of intellectual property rights: copyright, trademarks, geographical indications, industrial designs, patents, layout, undisclosed information. Anybody want to know what, say, geographical indication is? I don't have the time to go into each one of them. So geographical indications. Does anybody have? Let's have a conversation. Maybe people can volunteer. What is the understanding that you have of geographical indications? Anybody? Is there any particular commodity in India which is covered by geographical indication? That's a nobody?
Sir, this is Advocate Rajshekharan from Tirupur, from Tamil Nadu.
Yes.
Geographical indications here in Tamil Nadu, we have Tirunelveli Halwa, which has been marked as geographical indication.
What is the principle of it?
Sir, that should be traditionally from that place for so many years, and the production or the manufacturing should have happened in that place, and it should have been worldwide a renowned product that is originating from that place.
You're basically right. So, for example, basmati rice is actually from India and Pakistan. You can grow the same rice in Texas as they did, and they called it Texmati. So, a suit was launched by Indians in the United States, and they said you're actually copying our and actually infringing our geographical indications. And the suit was decreed in favor of the persons who actually didn't want Texmati. Texmati is very similar to basmati. So that's a geographical indication. So we won't get into all of them, but have a look at it and you'll get an idea of what sort of... Now, what is a patent? A patent is not a positive right. It's an exclusive right to exclude for a limited period. It is for now 20 years after the TRIPS agreement. And moreover, they are territorial in nature. So you cannot have a patent in India and then say, because I have a patent in India, I'll have a patent in England. Okay? So they are actually territorial. You can have a patent in the EU, and if you get a patent in the EU, it is applicable to the whole of the EU. And again, sometimes a lot of the patent advocates say, well, we've got a patent in the US. We say, sorry, you can't get it on that basis. You have to show that it complies with Indian law. And Indian law is very different, as I'll explain to you. So because it excludes others, it creates a monopoly. And it has its own consequences, which I'll talk about. So now, because patents are negative rights and they exclude and they create monopoly, what happens is, because of the monopoly, monopolist prices are created. Is that clear? Because I'm the sole holder of a patent, nobody else can make it. And what they can't do is make it, use it, offer it for sale, sell, or import. They can't do that. If they can't do that, I have a monopoly if I have a patent, and I can charge anything that I want. Okay, though the international law says it should be affordable, in reality, it's not the case. So there are number of medicines, for example, muscular dystrophies medicines in India cost crores of rupees. Okay, so nobody can access them, and people just die because of that ailment. And there's so many other diseases like that. Now, very importantly, patents can be for products or processes. And I want to ask you a question. Suppose I have a patent in a product, say like halwa. Of course, you can't have a patent in halwa. And let's assume for a moment you can. Will that create an absolute monopoly or not? What do you say?
No, sir, it will not create absolute monopoly for over a period of time. Maybe a restricted period of time, it may be allowed.
Yeah, 20 years it will be a monopoly or not?
Yes, sir.
The period. Now, assume that we don't have a patent in the product. We have the patent in the process. So what is the meaning of a process patent? Suppose a drug can be made from 3 constituents, A plus B, AB, plus C, A, B, C. That's one process. Now, can ABC be made in another way? Can it or not? Just think of juggling the ABC. How do you join them? First A plus B and then add C. Either you add C at the end or you add it elsewhere, but then it will become ACB. So you can do that. You have A plus C and insert B in that. So that's another way of doing it. So if I have a process patent in ABC by making it the following manner, A plus B, AB, and then add C to it. Another person can make it by actually adding A and C together and inserting B. So I don't have an absolute monopoly in the process patent. This is very, very important. And this is the thing that India used to overcome a lot of problems. So, as I said, product patent, once there's a monopoly in the period that it is allowed, as I said earlier, it's 20 years under the TRIPS agreement, then there is an absolute monopoly. Therefore, monopolist prices can be dictated. Whether they are not or are they dictated or not depends on the local government in terms of the domestic government, whether there are laws and whether there is a will to change it. And if there is a process patent only protected in law, then if there's one procedure, there can be another procedure. Okay, so there's not absolute monopoly, there is competition. And if there's competition, you can lower prices. This is very important to understand. I made it very simple, and somebody will ask, oh my God, it's so simple. Why are we bothering to think about these things? So what is, just to recap, product patent, exclusive right to make, use, offer for sale, sell and import a patented product, absolute monopoly, no competition, monopolist prices. In the process, right to use the process and use, offer same criteria, but if there's a relative monopoly, competition, and therefore there's lowering of prices. Is that clear to everybody? Okay. Now, what is the justification for patents? There is a justification, though in my view, there's no need to have patents at all. That's my view. But unfortunately, business actually trumps in these areas because they want to make money. And it actually is at the cost of the right to health of large majority of the population in the world. But the justification is that it encourages public disclosure of useful inventions. But the contrary impact is that it creates a monopoly, hinders competition. And if there are too many patents on a particular product, as there are in medicines, for example, even in a computer, for example, there'll be hundreds of patents. It actually discourages the free diffusion of technology and advancement. But there is literature on this now. There's a lot of debate. And one of the very important books on this is the one by Baldwin and Levine. And they've argued the case against patents. But it's not easy to do that because in the US, which is the most important country in terms of fashioning laws on these areas, businesses have the right to lobby. And lobbying means money. And that's where they're very strong. Now, what is the difference? During the period of 1995, when the TRIPS agreement was to come into force in number of countries, it was signed on 1/1/95, and it was to come into force over a period of time. And in India, it was to come into force on 1st January 2005. We had varied prices of the original inventors and those of generic versions. For example, the very famous Gleevec case of Novartis, the difference in price of the drug, Gleevec was the Novartis's drug. The actual drug is imatinib mesylate, crystalline form. The difference is, as you can see, $2,400, the originating price, and in contrast to that, $160 to $200. So you can see the difference. It's not even 1/10. Similarly, the combination of antiretrovirals, tenofovir, amitriptyline, efavirenz, which is a combination drug to treat HIV. The difference between the Gilead price, the monopolist price, was $1,800 to $15 per patient per month. So the difference is huge because of competition. So ideally, we should have competition, but patents don't allow it, and that's the problem. So just recap, I don't want to get into this again. Now, earlier on, sorry, my mistake, before 2005, in the old days, in the 70s, we had the British law of patents in India. And the protection was both for product and for processes. But the period was 7 years. Okay. Now in 73, it changed. Okay. We did away with product patents altogether. And that happened because Mrs. Gandhi, who was the Prime Minister, she was very worried about the prices of medicines for poor people. Today, she's being castigated for being a person who brought in the emergency. I was one of the critics of Mrs. Gandhi at the time, and our office was raided in 74 because of our opposition to Mrs. Gandhi, and our office was raided also by the present government. So we not liked by both of them, but we don't care because we are happy that we are opposing for people's interest. Anyway, so Mrs. Gandhi actually requested some experts, and the experts were two judges. And these two judges, Justice Bhakti Tekchand and Justice Iyengar, gave a report on the basis of which the protection for product patents and process patents was replaced by only protection for process patents. So what happened? There was no monopoly on pharmaceutical products because there was relative competition. As a result of that, there were more than one manufacturers in India. The generic companies were actually not even a shade to compete with multinationals at that time in 1970s. We had the highest prices in the world. And after 1973, the things changed completely. We became the largest producer of pharmaceutical medicines. We are literally the producers of all the generic versions in the world. So if you can see this chart, we became net exporters. Basically, generic companies were exporting as well as catering for domestic production. From 1974, they increased their production. Trade balance was negative, but it changed to the positive in 1888, 89 of the last century, and we never looked back. And that is the result only of one change. Please understand that. A very wise decision by the government to change the law. Okay, and this is from the chapter in Mr. Sudeep Chaudhary's book, who is one of the leading academics in India on patent issues. And you can see the production of drugs is going up and up and up. And in the late 90s, we became the largest producers of ARV drugs. Now we are the largest producer of generic drugs. In fact, before COVID, we were the largest producers of vaccines. Now we've been relegated to 3. That's a different issue. We won't go into that today. Now, if you see here, because they could reduce the prices, they could actually export them. What happened was, the result of that was, at the turn of the millennium, you see this chart, there was a huge crisis in the availability and accessibility of antiretroviral triple combination drugs, which were there to treat. So at the turn of the century, the lowest originator, that is the inventor's price, was $10,000 approximately per patient, okay, per year. Now, I was there in the South African conference when Dr. Hamid of CIPLA decided to actually do a very interesting thing. He announced that they will produce antiretrovirals at a price of about $500. Okay. What happened? The prices plummeted. If you see the red line, from $10,000 approximately in June 2000, in September 2001, it became in 727 of the originator company. Why did it go down? Because they had to slash their prices to compete. Okay. That is not to say they were not making a profit. They were making a profit even at 727. Can you imagine how much profit they are actually making? So let's assume they were selling at 1,000 rupees and 10,000 is their actual price. So $9,000 is profit. Imagine. So the cost may be $500, but they are selling at a profit of $9,500. Is that a conscionable profit in the area of health? I call it criminal profits. I'm not very popular with the originator companies, but if you don't talk, nothing changes. So this is very important, and this is the result only of that slight change from process patents being and product patents being protected. Only process patents were being protected. This is the history which we must understand. Now, this had to change because the multinationals were not happy with countries like India. So what they did was they wanted to change, and they wanted mostly American music companies and American pharmaceutical companies, as also the European ones, but primarily Americans. They thought that every country should have a law on intellectual properties like they have in the US. So, like they drink Coca-Cola in the US, we must also drink Coca-Cola. Okay? Both are bad for health. Coca-Cola as well as intellectual property. And this has to be understood, but they're not doing it for our benefit. They're doing it only for their profit. And you must distinguish the US government and the corporations. Until COVID, the US government, through the US trade representative, only spoke what the pharmaceutical companies told them. Only during COVID, because there was a huge problem, the US trade representative actually agreed to TRIPS waiver, which is completely unusual. But anyway, I'll come to that. So they wanted to change, so they started thinking of procedures as to how to change that. Now, I don't want to get into that. So this is what I've said. They actually then used the World Trade Organization to ram through, literally push through the TRIPS agreement, trades-related intellectual property. Why do I say they push through? You can read literature on this. And there's a very good author who has actually traced the history. What did they do? They basically made sure that during the negotiations, they would tell each country, if you don't agree, we'll impose sanctions. Okay? Now, I don't know if you understand this, but if a country has sanctions imposed by the US, it means, what is the meaning of sanctions? If you want to export, one of the meanings is, if we want to export, say, software to the US, the tariff on our software will be double than that of other countries. What does that mean? Our products become non-competitive. Okay, so sanctions were sought to be imposed by the US. Now, there was a block of the developing world, India, Brazil, a lot of Latin American countries who wanted to oppose this. But because the US was threatening to impose sanctions, each of these countries were sort of broken, and they actually agreed with the US. And they did it on the basis of what is known as the US 301 and US 301 special, which is a domestic US law which allows the President of the United States to impose sanction on a country which doesn't actually agree to the US prescription of their domestic law. Even today, for example, under US 301 and 301 special, India is actually blacklisted because we don't agree with them on a number of features of intellectual property law. Now, that's a threat that is used. Now we are not worried because we are a large developing country and our GDP is going up, and they know that we can't be pushed around. But in the 1990s, we could be pushed around, as could China, as could other Brazil, for example. But their agenda, and this is very important to understand in the context of the free trade agreements, that their agenda was to harmonize intellectual property, meaning thereby that whatever the law is in the US, all countries must adopt that law. Okay? But we didn't do it. And that's why the free trade agreements are being entered into to force us to have the same law as in the US. It's changed a lot because of other reasons. But what happened was during the negotiations, we agreed, apart from being beaten down by 301 and 301 special, we agreed because we thought that we were getting what are called flexibilities, which I'll explain in a minute. But the MNC, the multinational corporations agenda has always been to have a harmonized intellectual property laws throughout the world. Okay. Now, as far as the TRIPS agreement was concerned, it was entered into on 1st January 1995. India was the signatory to it on that day. It adopted a global standard and it included all the intellectual property rights that we have talked about. But importantly for patents, it was for 20 years protection, both for processes and products. So India had to change its laws, which was only for process patent production, to both process and patent product patent. Is that clear? Now, we didn't have to do it immediately. We had to have the 20-year protection over a period of time. So countries were actually given different times. The developed countries were given 1 year. Countries like us, India, we were given till 2005. Other countries called the least developed countries, they were given further period and now it's 33. Okay, that has been extended. In the TRIPS agreement, there's a specific procedure. The procedure is that suppose India doesn't do certain things which are mandated under the TRIPS agreement. Like, for example, there was a particular procedure for the interregnum from 1995 to 2005. Instead of having product patent protection, we were supposed to have what are called exclusive marketing rights. In that case, a country could take India to the dispute panel, and if we lost, which we did, it could go to the appellate dispute panel. And if we did not bring in the laws as stipulated and mandated under the TRIPS agreement, sanctions would be imposed. And what happened in India? In India, we didn't actually do it. So we were taken, ultimately we had to do it. Okay. Now, what are the periods? I've already mentioned 10 years LDC, now 2033. Patentability, the criteria has to be in novelty, inventive step, industrial application. So that criteria for novelty, inventive step, it's throughout the world. But what is the meaning of novelty? The domestic law can figure it out. Okay. Similarly, what is inventive step? The domestic law can figure it out. Industrial application is very clear. But it also provided that if the government thinks that voluntary licensings don't work, as for example, in the case of cancer drugs, we ask for a voluntary license to produce a drug which is very expensive. The government can issue compulsory licensing. Then there are other procedures. I don't want to go into that, but these are known as flexibilities. Okay. Or whether we should have an opposition, for example, I'll describe this later, but oppositions to a patent application, what type of oppositions, pre-grant, post-grant, etc. These are called flexibilities, and it's up to the state to decide what sort of flexibilities you should have. Because of these flexibilities, we agreed and signed on to the TRIPS agreement on 1st January 1995. But we didn't expect that the multinationals will continue to press for the same harmonization. We thought after we have agreed to the 1995 TRIPS agreement, there'll be a sort of a ceasefire and things will be hunky-dory. Well, the multinationals are now on a war path and they are trying to get the same things through what are known as free trade agreements, which I won't go into today, but some other time. So we can have a quick look at all these things. But what is the flexibility that we have? I won't go into section 3D, which I'm going to do it later. Pre-grant opposition, that is before you file, before the patent is granted, once the application is filed, there's a procedure to oppose before the grant of the opposition. Post-grant, as you can imagine, is after the grant of the opposition. There's also reviews, there's revocation, there's counterclaims. These are actually methods of knocking out the patent. Why are there so many? Because the law understands that a monopoly is not a good thing. And a monopoly can only be granted after the utmost strict scrutiny. You can't have light scrutiny over this and get a patent. So the law allows various stages. Suppose the patent is granted. What is the meaning of post-grant? After the pre-grant opposition is actually rejected and the patent is granted, again you can have a post-grant opposition. Now they want to change that because obviously they're not happy with it. In India, we have very strong civil society, which we developed, which actually does this. So they can't get patents very easily. Then there are review. Now revocation is another procedure after the patent is granted, and that is done through the what used to be called the now it's done in the High Court. Earlier it was done in the office of the patent controller. Now this is very important, counterclaims. In an infringement suit, after pre-grant, post-grant, if there is an infringement action, that is, somebody is actually manufacturing and selling, mere manufacturing is sufficient, the patented drug, then the owner of the patent, the patentee as we call him, can go to a civil suit, mostly High Court, and get an injunction against the infringer. At that time, the infringer can say, no, your patent is not valid. And that is done through an action of what is called counterclaim. That is what a counterclaim is. So there are three: pre-grant, post-grant. Review, as you know, it is very simple. Revocation is revoking, but it's after this. And the fifth one is counterclaim. Why so many layers? In fact, that's what the multinational are saying. Why do you have so many things in India? Because we don't want to have non-meritorious patents to be granted. Then apart from that, assuming the patent is properly granted and the grant actually makes the prices very high or doesn't make the patented drug available, then you can get what are known as compulsory licenses. And compulsory licenses are by the government, which allows a generic company to make the same drug at a price which is affordable and make them accessible physically and geographically as well as economically affordable. So there are provisions under our Patent Act under section 92 and 100 which allow this. BOLA provision is a specific provision where in the judgment by its name, BOLA, in the US, they allowed the generic companies to make what are known as experiments. Because on the one day after the 20th year, the generic company can come and manufacture, sell, offer for sale, etc. But if they don't have an approval of the drug controller, they can't do it. So there's a provision which is the BOLA provision, and it's in our Act, the 107A of the Patent Act, which allows a generic company to do experimental runs. And the experimental runs, by the way, are production runs. They need to be 30% to 50% depending on the country's laws. So if the final run is 100 tons, you must do 30 or 50% of that, and also do stability studies to make sure that each tablet are actually conforming to the specifications of compositions and efficacy. So this is maybe a bit complicated, but we can have questions on that later on. So now, as I said, 2000, turn of the century, there was a huge problem. Antiretrovirals were not available. The TRIPS plenary body, the ministerial conference, had to step in and say, and the multinationals opposed compulsory licenses. When a compulsory license was granted in India to NATCO on the anti-cancer drug, they opposed it and they made the Indian government's life hell. You are not complying, etc., which is all wrong. But the ministerial conference of the WTO, which is the body of the overseeing the TRIPS agreement, they had to make a declaration that no, the multinationals are wrong. You can issue compulsory licenses. Okay, I'll come to that later. So, compulsory license is very simple. Sometimes people don't understand it. Suppose I am a producer of a drug in the US and I want it to be marketed in India. I'll have an agent, right? I'm actually present in India through a company or whatever. So I'll enter into an agreement with, say, Keshav. Both of us are agreeing to it. It's a voluntary license. I give the license of my patented drug to ABCD in India to manufacture, sell, etc. That's a voluntary license. As opposed to that, a compulsory license is by statute a non-consensual license by the government. Okay? Of course, it's challengeable. And if it's granted on grounds which are not available.
200 में हो जाता है 155 में तुम बोल रहे हो नहीं होगा यार अच्छी वाले क्या
Can we stop? Please?
Yes, sir. Sorry, sir. I'm just taking appropriate action.
Yeah, okay. No, anyway, so the Doha Declaration was important that compulsory licensing is a procedure part of the TRIPS agreement and countries can resort to that. But any country resorting to that has to face a huge amount of pressure from the US and the European countries not to use it. So you can imagine the problems that we face. Okay. And compulsory licensing is actually permitted under 31F and 31 bis of the TRIPS agreement. We are not getting into that because that's another complicated procedure. I've already explained to you what the pre-grant opposition is and the post-grant, but post-grant and pre-grant under Section 25 of our Patent Act are identical grounds. Okay? Didn't have to go there. But the difference is, whereas any person can file a pre-grant opposition, even a foreigner can file it. In the case of post-grant, a person has to be a person interested, which normally means the person is a researcher, the person is in the industry, etc. It can't be anybody. Okay, they have to show some nexus to the issue. So, in the very famous case, one of the cases, an NGO working on hepatitis was also declared by the Intellectual Property Appellate Board to be a person interested. And the Madras High Court later on then kept that question open, didn't actually rule on it. Now, I've already talked about the counterclaim. Counterclaim is about an infringement action, and that time when the infringer actually goes to court and says, though I may be infringing this patent, but I am arguing that your patent is not valid. I am actually now opposing it to revoke it by a counterclaim. Now, in India, compulsory licenses are granted under various provisions. Section 84, where these are the criteria: reasonable requirement not met, reasonable affordable prices not, invention not worked. What is the meaning of invention not worked? The invention is granted a patent for a reason. You must work the patent, meaning you must manufacture it and make the drug or the patented product available. If you don't work the patent, it's a ground for actual compulsory license or even revoking. Then these are done, 84 is done through a private company or a private person. They go to the patent controller and it's like an adjudicating process, whereas 92 and 92A and 100 are actually done directly by the government. So there's no adjudication, okay, by a person interested who wants a patent to be overridden by a compulsory license. So there are various procedures. Now, NATCO's case, where cancer drug, Nexavar, was granted a compulsory license where I appeared, that was done by NATCO. So they went to the patent controller, furnished the grounds for the compulsory license. Patent controller granted it. They challenged it in the Bombay High Court, was defeated. Challenged it in the Supreme Court, it was defeated. In case of a TB drug, two of them, I'm the counsel for the party, the TB affected persons, to get compulsory licenses issued on two drugs of TB, which are very, very effective. That matter is pending. So these are different methods. I'm not getting into the details of it. So any questions now? Because I'll finish in about 10 minutes, but I wanted to go into a couple of things. Any questions? Otherwise, I'll finish in about 10 minutes and then we can have question and answers.
So
No.
you finish first, then we
Yeah.
take.
Now, one of the most important things in patents is what is known as patent evergreening. So a drug normally is actually invented in its base form. If you understand what is a base in chemistry, it's like sodium hydroxide, and it is reacted with an acid, hydrochloric acid, and you get sodium chloride, which is a salt. So normally a base is the invented product, but it's not very soluble. So what happens is they make it into a salt form, which is more soluble. Then they will make it into a liquid form. A tablet form is not easily taken by, say, a child, but you can actually give a drip to a child or an animal. That's liquid form. So these forms are also sought to be patented. There is no difference in the actual efficacy, okay? Because the efficacy is based on the actual, what is known as the active ingredient. The active ingredient will be imatinib, not the mesylate. Mesylate is a salt, not the crystalline form. That's just a form. It is the active ingredient when it goes into the body, that is what is effective. So the forms have no difference in terms of efficacy, but they're sought to be patented, and they are patented in Europe and America for the asking. Or, for example, there are two drugs which are patented, like we have combinations. One is patented, the other is patented. You combine them, and there's a new patent for a combination. So this is a very common form of getting a patent. Suppose, like we have the case of combinations. We have an example here. So ganciclovir was patented in 1982. Ester, which is like a salt, organic salt of ganciclovir, was patented in 91. Now, the combination of that is sought to be patented in 94. What happens is the 82 patent would actually expire in 2002. But 94 will expire in 2014. So you're extending it for 10 years. But you may ask, but they're the same drugs. Why can't the doctor prescribe these two separately? No, no doctor will prescribe. They will only prescribe what is a combination because that's easier. Okay. So this is one of the ways of extending the patent period. And this is known as evergreening. Okay. This is very common, and without really doing any work on the getting up invention, real invention, meritorious invention, they are being granted. Now, we had a problem in 2005 because we were supposed to change our patent law to comply with TRIPS. What we found was, and this was government and civil society and bureaucrats, they were working together because we had to change our law from only process patents to product and process. So what we had to do is research. We had to find out how to go about it. So we found that 76% of the drugs which are granted patents and approvals in the US and in European Union had no real therapeutic benefits. This is what is known as FDA, Federal Drug Administration data. Okay, so what to do about this? So we came up with an idea, and that is known as 3D, which is the bet noir of all multinationals. We said, well, when we first proposed, we said, new forms, don't grant them patents because there is no therapeutic benefit. But then the multinationals also got into act, they also lobbied. So there was a compromise, as it were. A new form will not be given a patent unless it is significantly efficacious over the known product. Okay. So that was the issue in the Novartis case. Okay. Now, I'll come to this. So Novartis case is about this. First, during the period of the interregnum, 95 to 2005, there was an exclusive marketing right. I've already given you the figures of the prices, but they actually filed an application. We opposed it. Patent controller rejected it. He said that this is not novel, there is no inventive step, and it is a crystalline form of a known substance, that is mesylate, over known substance, imatinib, and there is no significant difference in efficacy. Out. Okay. High Court. Now, what they did was they did not challenge it in the IPAB. At that time, there was the IPB. That was now is substituted by the High Court. So they challenged 3D in a High Court under a constitutional jurisdiction. 3D was challenged. They said, oh, efficacy. What is the meaning of that? This is all rubbish. Okay. And even enhancement, there's no meaning. Forgetting that this was taken from the European Union legislature law and the procedure where Novartis actually goes there every day and talks about efficacy. They just lied. And we found out and we showed to the court that they're just lying about what they don't understand. So ultimately, the court actually held in our favor and said that this amending act is to ensure that life-saving drugs are available to people, and the government has to discharge its constitutional obligation to provide good health. So you understand the linkages. Yeah, then Novartis filed an application to the IPAB. The IPAB actually interestingly said it's novel, it's also inventive, but 3D is not satisfied. And that was the case also in the Supreme Court. But the word used is efficacy, and they said efficacy means therapeutic efficacy. But Novartis had also said, oh, it has flow properties, meaning, example, salt, common salt, if you have common salt, it has an additive which doesn't allow water to be absorbed by the salt. If that is not added, you can't actually get the container, and if you turn it, the salt won't come out. So all the salt you have at home as an additive allows flow. Similarly, they said, and very importantly, that it is more bioavailable, meaning once it is a crystalline form, it's pure. Once it's a salt, it's more soluble. More of that substance comes to the target organ. But the court said it may be that instead of 110 are coming to the target organ, but you have to show by independent research that it is indeed significantly more therapeutically efficacious, which they didn't do. So Novartis case was rejected. So I'm going to stop here. I think I've taken a lot of time and I hope you're not bored, but it's very interesting now. We have half an hour for questions and answers and maybe interventions. I am not one of those people who believe that I have the only knowledge. Everybody has knowledge on this. So please go ahead.
So, first of all, thank you so much. It was actually so elaborately and detailed, the entire expression of not just the concept of medicine or the right to health, but also the expression of intellectual property and copyrights and patents. So I request everyone to kindly put forward their questions before I hog the questions. All right, so we'll take the questions from everyone as they come. I request you to kindly just raise your hand whenever you have some sort of a thought that you want to ask. So, one very interesting thing that
My name is Anand, Yeshav, not sir. Let's not have this hierarchy, a caste system.
So actually, why I choose to use the word sir is mostly and primarily because it is the valuable contribution, sir, that you have put forward with so much of your experiences throughout your life. You've chosen your own way of moving forward. You've sacrificed, you've dedicated yourself to such capacities and to such levels that is something which may eventually, at least for me personally, I know that is something which is most valuable. And to everyone who is here, sir, we're actually very esteemed guests over here. Wonderful people. I see Anjuvali Tikku ma'am also there, and she's one of the most, how do I say, most influential teachers that I've had in my life. Ma'am, hi.
Who's that?
Sir, this is Anjuvali Tikku ma'am.
Hey. Oh, nice to meet you,
She's
man.
been my professor. Ma'am, you're on mute. She's been my professor at Faculty of Law, Delhi University, and one of the
Great.
influential
Nice
teachers
I love teaching.
who has everyone, ma'am, everyone for that matter of fact. Ma'am, please, for that matter of fact, it will be very nice if, ma'am, but you're on mute. You will have to unmute.
Namaskar. Namaskar, Anandji. It was really nice to hear you. And since right to health happens to be my interest area, but I wanted to learn the TRIPS part of it, that when we talk about access to health and right to health. So, yes, as far as constitutional rights are concerned and uh, things relating to healthcare are concerned, I would always compare it with right to education. That we have made fundamental right to education as 21A, but as far as health is concerned, we do not find anything explicitly in fundamental rights. Though we understand that when we talk about fundamental rights, uh, in comparison to Part 4, Directive Principles of State Policy, there is always that issue of justiciability. But be that as it may, my core question would be that what may possibly be the reason that we are so much sticking around to right to education in comparison to right to health, realizing that a right to education is meaningless until and unless we happen to have right to health. That would be my question to you, sir.
So sorry, there was this.
But can we take some more questions or you want me to answer
Sure.
them?
So again, any
Whatever you say.
so please, as per how it goes, let's just take every question individually, sir.
Well, I think the professor has made a very important point. I think if we in India rated education higher than health, then there's no question of taking one and not the other. All fundamental rights, including, and health is a fundamental right in the International Convention. We are bound by the convention. The question is whether we should include it as part of a fundamental right, because there are enough judgments which point to the fact that the right to health is a fundamental right. It's like in the right to education, the 21A, they restricted it to a particular age group. So there can be a negative side to when you have the legislature and parliament legislating on it. But I think the point is well taken. It has to be considered a fundamental right, which it is in our jurisprudence, though it's not explicit in the constitution. Now it's well settled that the right to health is fundamental. But I think I also feel, why should it not be an explicit right? And we should maybe think about doing that, but I am worried they will actually restrict the right, which can be played upon by the courts later on. Thank you.
Thank you, sir.
Thank you so much for that valuable question. With respect to the things that you mentioned, sir, I'm just briefly going over the facts that since there is so much restriction on the access to medicine, actually the efficacious access to medicine through the concept of intellectual property, which is mostly governed in this sphere by the patents law. So the concept of evergreening in today's manner, just in as a layperson, someone who does not have very detailed knowledge of the subject, as yourself, sir, is it that big a hindrance? Is that the reason why people are not getting life-saving drugs? And so people, I just very humbly want to add on to this, that yesterday itself I was having a conversation with a person who was of very, very limited means, and that person has someone in the family who has cancer, and his biggest problem was that the expenditure which he was having to incur even at government hospitals was a lot.
Yeah, as I told in the beginning, 50% of the cost of healthcare is the cost of medicines. So if the cost of medicines is very high, then it's very difficult for poor people to secure their right to health. In fact, in most of the government hospitals, all the paraphernalia, etc., tests are done at a very cheap rate, especially Delhi, Punjab now, because the AAP government, and even Rajasthan. Rajasthan has a right to health, so it's quite good. But when it comes to medicines, there's nothing they can do if they are patented. And the importer of a patented drug, as I said, say, for example, spinal muscular dystrophy drugs, they are orphan drugs in the US. Very few people are afflicted by it. And the costs are running into crores per year. You know, like 200 crores, 100 crores, 50 crores is just unaffordable. There's litigation going on, but according to me, that litigation cannot help unless there is a generic company available to manufacture and there's no patent on it. The generic companies don't want to enter the what is called the patent thicket. I remember when the Novartis case was going on, Mr. Salve, who was appearing with Cipla, and I was appearing with the patients. The Dr. Hamid said, the cost of litigation is so high, we just can't afford it. So they stopped fighting the innovators. So now only civil society fights innovators. Right now we are fighting a case on TB drugs, we are fighting a case on hepatitis drugs, but our resources are limited. Now I can appear in some of the cases free of charge, but it's, the capacity is limited in terms of how many cases I can do in a month. But other people are not ready to do this. So you face a situation where the monopolists get away with what's going on. And the government is not interested. I'm sorry to say, the government is in fact thinking of amending and getting rid of pre-grant opposition. Can you believe this? The latest patent amendment that is sought to be brought into force is whittling down even these safeguards.
So, how it is the basic defense or the basic argument in favor of these corporations and in favor of the patents law, as it would be that it is an incentivization for their innovation.
Okay.
So where does that?
I didn't have time for that. Let me tell you how much is the so-called incentive. The same slideshow, I'll go on to that. And if you allow me, I have a portion of that slideshow which actually tells you what is the cost of medicines and how much are they charging. It's just shocking. That's why I use the phrase criminal profits. Unfortunately, people take it adversely, but it's the correct formulation in terms of describing this situation.
But absolutely, it would be a lot of money, sir.
Now I'll share screen. Okay, can you see it?
Yes, sir. Pricing of drugs, pharma
Yeah.
products.
I want to go on slideshow. Oh. Okay. So research, now there are two parts. One is the research of getting a molecule, okay? That is done in the lab. Then there are what are called clinical trials, which is to look at, and there are clinical trials involves what is testing of drug on animals. So those are known as animal toxicity studies. Then there are what are known as phase 1, phase 2, phase 3, human clinical trials. Then there are post-surveillance trials. Now, so drug discovery and drug development, these are the two nomenclatures which are important. Drug discovery is done mostly in government labs in the US. So what is the data available? Now there is what are called the DMASI studies done in 1999 and 2003. Those were industry-based studies that the industry themselves did the study, and they found out from collecting data, new chemical entities from 12 multinationals, that they found out that to provide and innovate, come out with an invention of a blockbuster drug, which actually sold 1 billion worth of drugs, was 231 million in those days. Okay. That is the first study. The second study basically said that it cost 800 or let's say $1 billion. But this was industry study. Then other people got into this issue and they looked at it and they found out that they have excluded what I told you earlier, that out of 100 drugs, 76% are new forms. There's nothing that is really spent on that. Secondly, legal fees of lawyers, which run into millions of dollars, are included in their costs. Marketing costs are included. 50% of the orphan drugs, where government gives money back okay, to the inventor are not included. So the US congressional, that is the government's own budget office, came to the figure not of 800 million, but only 100 million, 200 million, sorry. And Public Citizen, which is a NGO started by Ralph Nader, now run by my good friend Jamie Love, is only 100 million. The latest study, okay, says, and that is done by Donald Light and Rebecca Wharton, they said it only costs 56 million to produce a new drug, a totally new invention, okay? And this is actually very much in conformity with the tax returns that the companies file. So look at the data. Companies claim is 1 billion, but the actual thing is only 56 million. Novartis, they said they spent 400 million on Gleevec. You know how much they earned, or how much the turnover was in the first year itself? $1 billion. That is the state of data. So you can imagine how much money they are making. And this is also evident from the fact that during the 2000, the turn of the millennium, in South Africa, drugs which are costing $10,000 suddenly became available at $700. So that's what I was trying to tell you. So let's assume it's $1,000. They're making a profit of 500 US dollars. So $9,000 is their profit on 500. What is that? That's criminal profit. That's not reasonable profit. That's why you're paying. It's very sad, but this is how it is.
That's very elaborately and very well explained, sir. But so then there's this question which comes up with respect to generic. Sir, पहले तो मैं एक request करूंगा आपसे हिंदी में sir generic दवाई होती क्या है for people to get to know. There's been some discussion, but still people don't know it.
Sorry, say that again.
Sir, generic दवाई का क्या मतलब होता है?
Okay, okay. अच्छा, मैं हिंदी में बात करता हूँ. जो दवाइयाँ जो मिलती हैं, इनके लिए इसकी खोज और जांच करनी पड़ती है. तो करते हैं वो ज्यादा तौर पे अमेरिका में है, यूरोप में है और जापान में है. तो नई जो बड़ी बड़ी कंपनियां हैं वो गवर्नमेंट लेबोरेटरी से ना, सरकारी लेबोरेटरी से मॉलिक्यूल लेते हैं जिसको हम डिस्कवरी बोलते हैं. उसका खर्चा सरकार करती है, या यूएस गवर्नमेंट, एफडीए, जापानीज गवर्नमेंट या यूरोपियन गवर्नमेंट्स. लेकिन जो डेवलपमेंट होता है, जिसको मैंने बताया था एनिमल टॉक्सिसिटी स्टडीज, फेज 1, फेज 2, फेज 3 क्लिनिकल ट्रायल्स और फिर पोस्ट सर्वेलेंस, उसका जो खर्चा होता है वो कंपनी करती है. जैसे मैंने बताया, वो कहते हैं कि उसका $1 बिलियन खर्चा होता है, लेकिन एक्चुअली 50 मिलियन नहीं होता. अभी वो पेटेंट कर देती है. कानून के मुताबिक, ट्रिप्स एग्रीमेंट के मुताबिक, सर हर देश में पेटेंट कानून है, पेटेंट लॉ, जिसके मुताबिक जो भी दवाई हो या और भी कोई वस्तु हो, उनका पेटेंट का जो अवधि है 20 साल होता है. 20 साल के बाद पेटेंट ओनर, जो इनोवेटर कंपनी है, जैसे नोवार्टिस ने ग्लीवेक बनाया, 20 साल के लिए तो वो ही बना सकते हैं. उसके बाद कोई भी कंपनी बना सकती है. तो वो क्या करते हैं, वो उसका वापस खोज नहीं करते हैं. उनको, उस कंपनियों को हम जेनेरिक कंपनी बोलते हैं. ये इनोवेटिव कंपनी नहीं है, ये जेनेरिक कंपनी. वो क्या करते हैं, उनको दो चीज करनी पड़ती है. वो ट्रायल जो करते हैं उनमें पहले तो वो लेबोरेटरी में देखते हैं कि जो वो बना रहे हैं वो दूसरी जो इनोवेटिव कंपनी की दवाई है एकदम एक ही किस्म की है, वो इक्विवेलेंट है. लेकिन इक्विवेलेंट केमिकली नहीं, बायोलॉजिकली. जैसे जिस्म में जाती है दवाई तो उसका जो उसका प्रभाव होता है जिस्म में, वो उसके जैसे ही होता है जो इनोवेटिव कंपनी का होता है. इसमें थोड़ा 10-15% इधर उधर हो सकता है, लेकिन 95%, 85% वही होता है उसका इफेक्ट, प्रभाव. उसके लिए उनको दो काम करने पड़ते हैं. पहले तो स्टेबिलिटी स्टडी करनी पड़ती है, तो कि दवाई रहेगी कि नहीं, गर्मी में रहेगी, ठंडी में रहेगी, वगैरह वगैरह. दूसरी बात है कि जो उसकी उनके अंदर होती है, दवाई में क्या होता है, दवाई में एक्टिव इंग्रेडिएंट होता है जिसका एक्चुअली असर होता है, प्रभाव होता है, उसके अलावा उसके पैकेजिंग होती है, मिठाई होती है, क्योंकि उसके आप अगर लेंगे दवाई बहुत कड़वी होती है, आप ले नहीं पाएंगे, तो उसको पैकेज किया जाता है कि पहले तो वो कड़वी ना लगे, दूसरी जब जाएंगे जिसम में टाइम के बाद वो दवाई निकलेगी जहाँ पे चाहिए, टाइम रिलीज होता है, तो वो दवाई के लिए उसके अंदर क्या कहते हैं एक्सीपिएंट डाले जाते हैं। तो वो दवाई बनाने के लिए फिर कॉम्पोजिशन जो होती है जिसमें अनेक अंग होते हैं, वो अंग जो है हर एक टैबलेट में वही हो, उसके लिए उनको 1-2 साल के लिए प्रोडक्शन रन करने पड़ते हैं। तो उनको नई दवाई का खोज जो नहीं करना पड़ता, जो पहली फेज 1 फेज 2 फेज 3 उनको वो नहीं करना पड़ता है, ह्यूमन क्लिनिकल ट्रायल्स नहीं करने पड़ते, उनको सिर्फ स्टेबिलिटी स्टडी करनी पड़ती और बायो इक्विवेलेंस करना। तो ये जो है कंपनियां, जो अलग कंपनी होती हैं इंडिया में, वो बहुत ही मशहूर हैं, जो दवाइयां लेके आते हैं जो ओरिजिनल ड्रग की जैसे ही होती हैं, लेकिन उनके लिए उन्होंने स्टेबिलिटी स्टडी की होती है और बायो इक्विवेलेंस की होती है। लेकिन सभी जो आजकल चल रही हैं कंपनियां वो ऐसे नहीं करते हैं, कई बहुत खराब है। जो बड़ी बड़ी कंपनियां जैसे सिप्ला वगैरह वगैरह, उनका अच्छा रेपुटेशन है, लेकिन क्योंकि सरकार ने नियम निकाल दिए थे तो अभी वो वापस चालू कर रहे हैं। सरकार ने नियम हटा दिए थे जिसकी वजह से आपने देखा होगा पेपर में भी आया कि दवाइयां गिनी गई हैं, उज्बेकिस्तान गई है वगैरह वगैरह, जहाँ पे लोग मर गए हैं। ओके, पॉलीग्लाइकोल एथेनॉल उन्होंने डाला, उन्होंने चेक नहीं किया तो उससे लोग मर जाते हैं। तो ये जो अथॉरिटीज है अपनी सरकार की, वो चेक नहीं करती हैं कि वाकई वो बना रहे हैं कि नहीं, क्योंकि यहाँ पे जो अपना सिस्टम और मॉनिटरिंग है देखने का सरकार की तरफ से, वो इतना मजबूत नहीं है, रोबस्ट नहीं है। और आपको मालूम है हमारे देश में प्रॉब्लम क्या है, करप्शन बहुत है। तो जो अगर अच्छी कंपनी से आप दवाई नहीं लेंगे तो वो दवाइयाँ का असर खराब भी हो सकता है। तो जेनेरिक कंपनीज के बारे में ये भी बोला जाता है। हाँ, अच्छी दवाइयाँ भी आती है जेनेरिक कंपनी से, जो उनका जो रेपुटेशन है जिनका अच्छा है, जैसे सिप्ला वगैरह। लेकिन दूसरी जेनेरिक कंपनीज है, उनका कंट्रोल नहीं है सरकार के उनको ऊपर, और वो कुछ भी कर रहे हैं। तो ये अभी एक्सपोर्ट के लिए सरकार कर रही है, डोमेस्टिक के लिए कर रही है कि नहीं हमें नहीं मालूम।
तो दवाइयों के मामले में सबसे एक वही रिक्वेस्ट कि प्लीज डॉक्टर से पूछे बिना, और गूगल बाबा से तो कुछ ना पूछें। आज द डॉक्टर, टेक योर मेडिसिन विद प्रॉपर एडवाइस ओनली।
और डॉक्टर भी आजकल क्या करते हैं, जहां पे उनको पैसा मिल रहा है वो उनकी प्रिस्क्राइब करते हैं, ये भी प्रॉब्लम है।
लेट्स प्रे। इसीलिए बोलते सर है ना कि एक अच्छा डॉक्टर मिल जाए, अच्छा वकील मिल जाए, तो उसके साथ रहो,
हाँ, अच्छा डॉक्टर मिलना बहुत जरूरी है।
फैमिली की
एकदम
तरह
सही
रहो,
है आपको,
फैमिली
एकदम।
की तरह रहो। So, because this is just following this conversation only, and only few questions I have, very limited, but I hope you'll find them relevant. So, sir, with respect to, now we've spoken about what exactly the pharmaceutical industry broadly is, or how one may see it. We've also tried to see what exactly is the concept of generic medicine and how it may look. Again, everything from an academic perspective. जो डॉक्टर वाला काम तो सब डॉक्टर्स के साथ ही बात करें. We've also seen the kind of challenges and limitations which are there. Also, obviously, all the steps that are being taken to improve that. But now, sir, I just very humbly want to take the attention back to where it all starts from. Now, where, sir, they say the father of surgery, modern surgery, which is considered an even more advanced form of medicine. That is also an Indian person, जो sir Shushruत जी की जो बात करते हैं, that he is also from India itself. We have a very large history of medicine system. We have Ayurveda, we have yoga. So we have all of these factors, sir. What are your thoughts with respect to that, and are they adequately developed? And if they're not developed, then why not?
Okay, I'll just give you an example of the litigation going on in the Supreme Court about a COVID medicine, which is homeopathic. So the Kerala government prescribed that everybody must take a particular COVID medicine, which is homeopathic. There was no study done. In fact, all drugs are supposed to comply with the Drugs and Cosmetics Act and the procedure which is prescribed. See, Ayurvedic drugs are traditional drugs. which have their own uh, effects, which are laid down in Ayurvedic texts. But they are not new drugs. You can't have new Ayurvedic drugs without going through the procedure under the Drugs and Cosmetics Act. You can't have new homeopathic drugs without going under the. So, like for allopathic drugs, homeopathies are subject to trials. Now, without doing those trials, clinical trials, you say, no, this particular drug must be prescribed for everybody. And they were actually distributing it. So ultimately, the Kerala High Court said, no, you go back and make your representation again to the government. They made their representation and the Kerala government threw it out. So ultimately, we came to the Supreme Court and the data shows that the drug has no efficacy. And if you want to go on homeopathy, there is another better drug. But people are not following, the government is not following that, you know. So this is a major problem because a lot of claims, and you can't make claims like this for COVID or HIV under the Drugs and Cosmetics Act. Those claims are debarred. There is a criminal action against that sort of thing. But people make, you know, some very well-known personalities will make sort of tall claims which are not correct. Now, for example, in COVID, a lot of claims were made about the traditional drugs. They don't have efficacy. You know, you have to be very clear about these things. Those drugs are not meant, you know, for diseases which are new. Those were not thought of. So you can use them for other reasons, you know, like taking inhalation. Those are other effects. You know, I do a lot of steam inhalation, which is good for your lungs. But that's not going to treat COVID or HIV or any other medicine like that. So we have to be careful. I believe that unless it is proved, don't take it.
So since we're just having an academic discussion, so in that spirit and in that interest only, and again, so understanding at least for myself, that I have obviously very, very limited knowledge of medicine itself. But just the fact that, so there have been a lot of people who have also not taken the COVID vaccination. So someone was mentioning on the show itself over here in the class, and so they also mentioned very similar thing. One of the faculties only, that they haven't taken vaccination, and that I don't know whether if COVID happened, obviously must have happened only. So how it was construed. So I'm just speaking on this line simply because of something which you mentioned, which intrigued me a lot, which was when you mentioned about lobbying from the US system of governance for whatever it is at the end of the day, it is influencing things, it is influencing thoughts of how exactly a perspective may be seen or witnessed. So, so in that respect, so is it not necessary that, you know, sometimes we just call it a new form of, you know, sometimes the hype is also created when so much
Yes.
done by
So
the.
if you read Justice Nageshwar Rao's judgment in Jacob Pulliel, you'll find out how in our system also there is lobbying, how COVID vaccines were given preferential treatment because they happen to be close to the government, etc. There was no data to show they were effective, etc. So this is happening all over the world, even in India, not only in the US. Because once our approval system allows a drug to be approved in India without doing clinical trials here. If it is actually approved in the FDA, the drug authority has the power to allow approval here, marketing approval here, without testing it or experimenting it here. Okay. They do post-market surveillance studies otherwise, but otherwise they don't require phase 1, phase 2, phase 3. But please read Jacob Pulliel's judgment by Nageshwar Rao, which tells you what was the data available for the approval of COVID vaccines. It's a revelation, you know, how it's going on. It's not a good thing that has happened. And I don't want to comment on it now. I'm writing about that on the COVID experience throughout. We'll in the leaflet which we publish, we are going to have a series of articles on COVID and vaccines and medicines.
So, so we look forward to these articles. And so, just parting thoughts, parting words. Sir, you've already given us so much of your time and your consideration. It's actually very valuable. So, what would be your suggestions or advice to young advocates or even so senior advocates also, judges also maybe, and also all people who have to be in such professions where there's a lot of sitting involved for reading, drafting. Right now also, so I think most of the people would be sitting only.
Well, in terms of drafting and litigation skills, I can do a separate this thing. But
So,
in
so
terms of, yeah, in terms of attitudes, I think the most important part of a lawyer's attitude is to be critical. Most important. If you're not critical of what you see, you're not going to be anywhere. You can do a lot of chamchagiri, as they call. It won't get you anywhere in terms of actual real results. The art of lawyering is to be critical of the other side. You need to develop critical faculties, not only of the adversary, but also of your own argument. So the critical faculties have to be natural to a lawyer. And that's what when I train a lawyer in whether it's Georgetown or anywhere else, I tell them, please don't accept anything for what it is saying. Please interrogate it. Please look into it at a constructively critical level. Suppose somebody says, this is it, don't accept it. Because if you accept it, you are not going to do an inquiry. And a lawyer, you must be able to conduct a constructively critical inquiry so that it gets you the result that you want. But in litigation, you have to always find out what is the plus of the other side, what is the negative, what is the plus of your side and negative, and address your negatives. It is, if you don't address your negatives, you may be a loser. Because frankly, if you read the judgment of the Jallikat, you'll see, I'm very sorry to say, the judgment just doesn't address any of the issues. But I think the spirit of inquiry has gone. In our system now, the spirit of inquiry and trying to find out what is a new issue, how to deal with it, is just gone. And it's a very sad state of affairs that we are living in now, where our courts are not really looking into things as they should be.
So, but we again, sir, we are, we have your blessing also. We have blessings of all seniors who actually come out and teach us. So I understand one thing, so that I hope and I pray that this initiative and various other people who are undertaking such initiatives, that whatever they're doing, that they may rekindle or ignite the spirit of inquiry, as you very
Yes.
Wonderfully mentioned, sir. So just one thought, sir, finally, because again, when we're speaking about health, sir, so much has been spoken about mental health and the mental faculties of health which are involved, or the biological faculties for that matter of fact. So what about the relevance of physical health for young lawyers?
I am very particular that, if you want to be a good lawyer and successful, please take care of your physical and mental health. Like when you rang me up at 10 o'clock, I was in the gym. So
Absolutely, sir.
every day I'm in the gym to do my exercises and meditation, etc. So I would advise, there are lawyers who will work in the mornings from 7 to 10, and that's not to decry them or denigrate them, but you must have time, 1 hour, 2 hours, for your body and your mental faculties to be developed. And that requires time and exercises, both physical and mental. And I think that's very important. Don't ever give it up. And also having proper nutrition, balanced nutrition, food which is not expensive, but good food, having a balance of fat, carbohydrates, and proteins, and minerals, and vitamins. And that doesn't require a lot of money. I am a cook, so I devise my own nutrition every day, But I think that is an art that you should learn, and it's worth it. It'll keep you in good stead for a long period.
So thank you so much for such valuable guidance and such kind advice. And obviously, I'm sure that a lot of people will want to go through this lecture, not just for the medicine or the medical part of it, but also for understanding how briefly and how well you've explained the concept of intellectual property also through this class. So we're absolutely grateful to you. And I thank you on behalf of all of the participants who have joined.
Thank you. Goodbye.
And an honor, and I hope and I look forward that hopefully we'll have further such occasions of interacting with you and learning about.
Thank you very much.
So,
Thank you.
Thank you so much, sir. So to everyone, again, thank you so much for being part of this humble legal literacy. Grateful to you for joining in regularly, but we very humbly request that kindly share your feedback, as these are free academic classes. And honestly, feedback is all the motivation that we can possibly get. We get to share it with all the faculties, the seniors who come. We get to also understand where we are probably lacking, what we may be able to do better. And again, it's your initiative only, and we're hopeful that this would have some kind of positive some positive takeaway for everyone. So with that, I very humbly thank you once again for joining us. If you have been with us for so long, kindly like, share, and subscribe. Please share with your friends also. Please share the meeting invites before the class also, if you can, with all students and all people who can possibly benefit from the classes. So with that, I humbly seek your permission to close the class. Thank you so much for being a part of this.